Good morning, everybody. We're just now getting started with today's webinar featuring Karonnie Truzy, and we are giving attendees a moment to join. We have people rapidly joining, and while we are doing that, I'll go ahead and talk just about a few housekeeping items. Utilize the functions that are at the bottom of your Zoom screen today. There's a Q&A where we would like you to log questions. Karonnie wants us to be super interactive, so he has given us permission to interrupt him while he's speaking so he can give timely responses to issues that he's talking about at that time. So if you will log those in the Q&A, I will interrupt him when he takes a breath, and we will address those as we go. We also have Mary Ellen Stockton with us today, our resident person who helps us with all things related to Zoom and technology. So if you are having any technological issues, please put those in the chat, and we will make sure that Mary Ellen is monitoring that and offering assistance as needed. We also have our Michelle Connolly with Case Metrics, who is always on screen with us as well. So one of the things I want to do before we get started is just to tell you a little bit about Karonnie Truzy and what he is up to these days. Karonnie Truzy is today's webinar host, and he is with CR Legal Team in North Carolina, where he is not only a partner, but he serves as their Chief Diversity Officer. He has been practicing since 2001, and he concentrates his law practice on handling complex injury cases. He also works on Section 1983 claims, commercial motor vehicle cases, and wrongful death cases. I initially met Karonnie through North Carolina Advocates for Justice, where he served on the Board of Governors, and he's been on a number of national stages since that time, including AAJ and Academy of Truck Accident Attorneys and others. He's also been featured on a podcast, Trial Lawyer Nation, and is a frequent speaker on the litigation circuit around the country, where our paths often meet. I feel like I'm always running into him somewhere. And we are very proud to have Karonnie and his firm in the Case Metrics network, and you will see his impressive results in the Case Metrics database. And now Karonnie is going to speak to us on deposition obstructions and how to deal with them. So I would like to introduce to you my friend and client, Karonnie Truzy. So take it away.
All right. So thank you, Kim. So good morning, everyone. As Kim said, my primary focus is litigation. And one of the things we were talking about this morning was the fact that, probably about 60 to 70% of our time as litigators is really spent in depositions. And so it's imperative for us as attorneys, as paralegals who are working for attorneys and getting these things ready, that we know some of the ins and outs of depositions and what we need to do in order to best handle these things for our clients. So what I'm going to do is I'm going to actually share my screen now so we can kind of get into the presentation. There we go. So as you know, what we're talking about this morning is essentially best practices for depositions, specifically handling obstructions and depositions. So inevitably, when you get into a deposition, you're going to run into different obstruction tactics from the other side. And so this morning, I want to have a discussion about what we do to handle those, what we do to make sure we alleviate some of the things that we can alleviate from the beginning, and actually how to make a smoother deposition. So see, there we go. So when I take a case in, I look at a case from the beginning and start framing the case. And I think that any attorney who does this type of work does themselves a really good favor by, from the beginning to think about the different things that you need in order to prepare this case at the end game, which is trial. When a client brings in a case, of course, I like this illustration, because when a client brings a case into us, there are 1,000,001 pieces. There are 1,000,001 pieces because clients provide information to us throughout the case. We learn different information throughout the case, whether it be through discovery responses or whether it be through depositions. And so from the very outset, it's imperative that we begin framing the case and taking these pieces and putting them together in what I like to call the litigation puzzle. So when we do take these cases and we put them together for not only our clients, but also for the jury at the end of the case when we're presenting these cases at trial. In order to make sure that we're doing this, one of the things I'm always, reminding folks of is that, you can be the best litigator in the country, the best trial lawyer in the country, you have the best speaking voice, the best appearance in front of a jury, but your case is still only as good as the facts. So from the very outset, there's no replacement from thorough investigation so that we can understand what we're doing on the case. Making sure that we've gotten through all the discovery before we begin to take these depositions on the case and we have a clear understanding of what we need to present on the case. Requesting privilege logs for things that have not been provided that we anticipate that we're going to need in order to present this case. And overall, making sure that we are prepared from the beginning. And I really like this slide because I think of this as when I meet with my paralegal and when I meet with our trial team in order to get these cases together, it doesn't just start in the 3 months before we have trial. The preparation for these cases actually begins early on when we first get the case in and when we're mapping out things and what we need to accomplish during depositions. I like to look at this as essentially creating the plan of what we need to do on these cases. So I prepare from the beginning an analysis of the case and what I need to prove on the case in order to win at jury trial. One of the things that I'm very strategic in doing, and I don't just do this by myself, I talk with other attorneys, I roundtable these cases within our firm, with other attorneys in our firm, even with my staff and paralegal, and probably the best attorney in my house, my wife, about different things, about defenses that may be applicable on the case, and what we'll need to defeat those defenses. I think if you begin thinking about those things in the beginning, then you're going to have a roadmap that you put together that you're going to be able to present at your deposition when you're asking questions that shows that you have a mastery of the facts of your case. I like to write out what I need to create a record in the case. So again, these are things that we're doing in the beginning before I do the very first deposition. So I'm writing out what I need to create on the record in order to prove the different elements of my case, as well as defeat different defenses, as well as anticipate different things that different witnesses may say in the case. I also create an outline of what I want to accomplish during the deposition. I know that some attorneys like to write out their questions and the things that they want to ask during the deposition, but quite frankly, I think that takes away from what I'm doing in a deposition. And I like to simply have an outline, a simple bullet point format where I go through and I actually take a look at what I need to prove on the case, what I want to get out from the different witnesses, and in anticipation of different questions that I need to ask, but I don't really write out my questions. Instead, I like to really pay attention to the answers that I'm getting from the witnesses. And in getting those answers from the witnesses, I can formulate my question based on the information that they've given. I also like to anticipate the evasive response that we have and have different strategies for how to deal with that. If I'm dealing with a commercial motor vehicle case, and I'm taking a look at that case, and I'm thinking I'm going to go in and I'm going to depose the driver, the commercial driver. I anticipate how they may try to be evasive. I'm taking a look at their prior driving history, and I see that they've got a crappy prior driving history, and they're not really going to want to talk about that. I figure out different ways to ask pretty much the same question, different ways, and so that I can actually get the answer that I want from that witness. And you can put a kind of a star in this kind of aside. One of the things that I like to do, if I don't get the answer that I want from the witness, I'm going to continue asking that question later on in the deposition a different way, still eliciting that question, that answer from that question. What I found is we get a lot of objections from attorneys for asked and answered if you continue attempting to ask the same question right after each other. So I like to space it out and go back to that question so that I can get an answer to it. So when we're talking about depositions and we're talking about these obstructions in the depositions, I think it's important to know what the rules of the game are. And so this is absolutely what I consider a game, and it's gamesmanship by the attorneys. And it's the attorney who has the best handle on the rules and how to handle those rules during deposition that is able to accomplish what they need in the deposition. So when we first look at those, the model rules of professional conduct really talk about fairness to opposing parties. And I think that's important in all the depositions. And when I'm prepping my clients, what I like for them to understand is, we're not here to hide anything from the other side, but we are here to make them do their job. And what that means is you only answer the question that you've been asked. We don't need you to go into a deposition and spill everything out that you know at once, but we need you to answer specifically the question that you've been asked. And if you do that, you're going to be ahead of the game, because the attorney then is not going to have as much ammunition on you to ask questions about. One of the things that we look at Rule 3.4 and this whole idea about fairness to the other side is that a lawyer shall not unlawfully obstruct another party's access to evidence. And so again, that goes in my prep session with my client when I'm prepping them for the deposition, as well as when I'm thinking about preparing my own deposition of the defendants on the other side. And when you take a look at the revised rules of professional conduct, and you're taking a look at Rule 3.4 in the comments, it goes a little bit in more detail about it, because it talks about fair competition prohibits the destruction or concealment of evidence. And what I found is that, in this whole new world that we're working in right now, where we've got social media and every party has a client who wants to get on social media, it is a big deal. It is a big deal that we instruct them properly before the deposition about how to handle their social media accounts and how they can't just go in there and completely wipe out their social media accounts, because our rules of professional conduct don't allow that. How we can't go into deposition and improperly influence a witness, and that includes our own witness and what we tell them. And probably one of the more important things in deposition is that we can't go in and use obstructive tactics in order to try and delay discovery in the case. One of the cases where, I like to have handy when I go into these depositions, and by the way, I keep a notebook handy with me when I go to these depositions, where I have a whole bunch of different case law about how to handle different things in depositions. And this is one of the cases that I keep in my notebook about how counsel should engage with the witnesses and how they should conduct themselves during the deposition. And if we're looking at this Geisinger case, one of the things that it talks about is that counsel should not engage in any conduct during the deposition that would not be allowed in the presence of a judicial officer. In other words, the thing that you should ask yourself is, during the deposition, the behavior that's going forward, is it something that would be permitted at trial? And when this outline, I practice in North Carolina, so you're going to see some references to North Carolina. What I've tried to do is kind of tailor it down to where we're talking more about the federal rules. I do practice in federal court also, and so I try to tailor these things down so that I can work with these things in federal court as well as with the North Carolina rules. Rule 30, which I've quoted here, Rule 30C specifically, actually has a sister rule in the federal rules that is almost identical to it, but I've got the North Carolina rule in here. And so if you take a look at that rule, one of the things that it talks about is that examination and cross-examination, that means both sides, should proceed during the deposition as if they are in trial. Okay, and this is one of the things that you should keep in mind when you're preparing your questions for deposition, when you're preparing your outline and how you want to handle a witness. The way that you're handling it during deposition, is it the way that I would handle it during trial? I'm going to be the first one to raise my hand and say, listen, Karonnie, you need to take your own advice, because from time to time, there are things that happen during depositions that, I probably wouldn't do that in front of the court. I wouldn't do that at trial. But for the most part, I try to abide by this rule, and I try to think about this whenever I go into a deposition. We need to consider this when we're going into depositions, and we're prepping our clients for these depositions. All obstruction is unethical. Okay, all obstruction is unethical, and we need to make sure that we understand this and have a good grasp on this, so that when we're prepping our client, we let them know that you can't do anything to hide evidence and testimony that would be proper in the case. If you're asked a question and it is a right question that you should be asked during the deposition, then your job is to answer that question. Your job is not to lie about it. It's not to try to hide the information, but your job is to answer that question. And so when we're taking a look at that, one of the things about this, again, this is one of the cases that I keep in my notebook for depositions, This is a Nix versus Whiteside case, a 1986 case, Supreme Court case, but it is still a good court, and it's still one of the key cases where we're talking about these kind of duties at depositions. And it says this: it says an attorney's ethical duty to his client is limited by an equally solemn duty to comply with the law and the standards of professional conduct. A lot of words, but what it comes back and says is I have an ethical duty to have candor towards the court, as well as an ethical duty to represent my client. And sometimes, those two duties may seem to butt heads, but I've got to make sure that I'm staying above board when I'm prepping my client and in the testimony that my client is providing during the deposition. Again, I can't unlawfully or unethically obstruct a deposition just because I don't want my client to answer something. What about being a zealous advocate? So, when I was going through law school some 20 years ago, that was one of the big things that they talked about, being a zealous advocate for your client. And, until I got out and actually started practicing, I really didn't understand what it meant to be a zealous advocate for my client. But the more and more I practice, the more and more I have these clients, the more and more I see that I'm becoming even more zealous for my clients because I believe even more in my clients. And so when we're talking about this whole idea of being a zealous advocate, there's a revised rule of professional conduct, Rule 1.3, where it talks about our duties as a zealous advocate. So again, the rule previously was that we had a duty to be zealous advocates for our clients. However, that rule has changed. And what that rule states now is that we have a duty to act with reasonable diligence and promptness on our case. It's remove this whole idea of being a zealous advocate for your client, even though I still look at this under the microscope of being a zealous advocate for my client. But it simply says I've got to use reasonable diligence in representing my client. When we're talking about these depositions, we've got to remember what the whole purpose of the deposition is. This is a case, that's often quoted in a lot of briefs where we're talking about obstruction and depositions. And essentially what this says is that a witness comes to the deposition to testify, not to indulge in a parody of Charlie McCarthy with lawyers, and how they're bending the witness's words to mold a legally convenient record. So what that means for us is we can't use these depositions to try, to use it for our advantage, to try and tell our clients how they need to testify. Okay? And if you're prepping your clients to do that, then you might want to take a step back and look at how you're actually prepping your clients for these depositions. Now, our goal at these prep sessions with our clients is to make sure that they understand what their duty is for the deposition. And I like to talk to my client about the aspect of your duty at the deposition is not to make your case any better or any worse than what it already is. Your job at the deposition is to simply go in and tell the truth and simply answer the question that you've been asked. Okay? And again, I think that if the client does that, everything else is going to follow itself and is going to fall in line. Okay? So probably about 15 years ago, I was at a CLE, and while I was at the CLE, the speaker was talking about some of the things that they do in the deposition. And one of the things that they talked about was this idea of video recording their depositions. I started doing that about 15 years ago, and I haven't looked back from doing it since. And the reason I say that you must record your depositions is because when you have a written transcript of your deposition, that written transcript can be defined by whoever's reading it, meaning that they're just black and white words on a piece of paper. Okay? And so when you're reading that deposition, it takes on the identity of whoever's reading it. However, when you video record a deposition and you're able to show that deposition and what was stated in that deposition in that witness's own words, in the attorney's own words during the objections, it takes on new meaning before the court. And I like to record my depositions simply because once that deposition is over, you cannot go back and recreate a facial feature, the tone in someone's voice. You just can't do that by simply reading a transcript. So one of the things that I would do, if you don't take anything else from this particular CLE, is that you actually record your depositions and use those depositions as tools for helping your case in your motions and presenting at trial. So objections. One of the reasons I record my depositions is because you get some attorneys that throughout the course of the deposition, they object to every single question that you ask. And from time to time, when you're getting some good licks in on the other side, when you're asking questions, they simply want to object with no valid reason, just for the sake of objecting. And so when we're talking about objections, let's take a look at some of the things that are allowed by the rules with regards to objections, and some of the things that are not allowed and are seen as obstructions in these depositions. So what are the required objections during depositions? Well, you're required to make sure that you object to errors or irregularities in the manner of taking the deposition. So that's one of the things that you got to make sure that you object about it during the deposition or before the deposition and have it placed on the record. Objections to the form of the questions. This is an important question, or I'm sorry, objection, because what that does is that makes the other side understand that you're going to be keen on the questions that they're being asked to your client. It also means that you're paying attention during the deposition and you're making valid objections to the form, and you're not simply playing solitaire on your laptop. Objections to the oath or the affirmation. Objections to the conduct of the parties. And that can be, not only for, and I really like this one because that can be not only for the witness, but also objections to the behavior of opposing counsel. And errors of any kind that might be obviated or removed or cured if properly presented during the course of the deposition. And when we're talking about this, this whole idea of objections and obstructions in depositions, you want to keep the Federal Rule of Civil Procedure, Rule 32D, handy during the deposition. And this specifically is covered in 3B of that particular section. Inappropriate objections during depositions. These are actually objections that you should preserve for trial. And it's got a pretty good list of things that, quite frankly, attorneys all the time make objections to during the course of the deposition that they really shouldn't be making objections to. And that can be the competency of the evidence, the relevancy of the evidence, whether or not some testimony is material to the case or not. What the rule particularly says about this is that these particular objections, they're not waived simply because you don't make them during the course of the deposition. However, the rule simply talks about the fact that those types of objections should be stayed for trial and made during the course of trial. Again, what are these inappropriate objections during the depositions? Admissibility of evidence or testimony during the deposition happens all the time, but is really not a proper objection. Relevancy of the testimony. That comes from attorneys all the time, as well as witnesses. I can't tell you how many times I've had a witness, I guess they watch episodes of Law and Order or, episodes of whatever the favorite legal show is. And, they hear these objections during trial and during the, deposition, and they want to make their own objections. What's the relevancy of this testimony? Why are you asking me about, who lives with me in my home? What's the relevancy of it? Well, those are improper objections by the attorney, and you really should instruct your client as a witness that their job is to answer questions, and you are the attorney who will be making the objections during the course of the deposition testimony. Beyond the scope of the deposition, another objection that's really not proper during the course of the deposition that we see done often. Hearsay. I can't tell you how many times I get objections. I'm trying to place some type of report in or some type of witness statement in that I want to question the witness about, and the opposing counsel's making an objection with regards to hearsay testimony in the statement. Well, really, that's not proper for the deposition. That's a matter that should be preserved for trial, for motions in limine, and for a presentation during the testimony that goes forward during trial. Speculation. Those are just inappropriate objections to be made during the course of the deposition. So inappropriate behavior during the course and scope of the deposition. I'm sure some of you have seen some inappropriate behavior by other parties, but I'm sure not by yourself during the course of a deposition. So what types of behavior is inappropriate during the deposition by the attorneys? Witness coaching. So this is a big one. This is a big one. And I did the CLE presentation a few months back over the summer of last year. And what I was very surprised at were some of the things that the attorneys just did not know that the rules allowed whenever a particular attorney is attempting to coach a witness. And so let's take a look at that. So of course, witness coaching is specifically prohibited during the course of a deposition. And so this is important. Again, this is a case that I like to keep in my notebook. When a defendant becomes a witness, this can be a defendant or a plaintiff. When they become a witness during the course of a deposition, that particular witness has no constitutional right to consult with his lawyer while he or she is testifying. That is extremely important. And again, keep this case with you. This is the Perry v. Leak case. There's no right for any consultation with the attorney during the course of a deposition. Okay? And so we often see during depositions that the attorney may ask for a break and an opportunity to go and consult with their client or with the witness, and we allow it. We allow it because, again, we don't really know the rules behind it, or, we just want to, have a courtesy to the other side. We allow it. And this can be us asking for an intermission to go and talk with our clients. So this is important to know. There is no constitutional right to that. And there's some things that happen if you ask to speak with your witness during the course of the deposition, or even if you don't ask, but have a conversation with your witness or client during the course of the deposition. So let's take a look at that. Can a witness confer with a lawyer during a break? So there's a split on authority about this and way, this is looked at throughout the country. And so again, I put this in here for those of you who practice in North Carolina. There's no clear answer in North Carolina state courts about this. However, again, I practice in federal court, and in the circuit where I practice in, which is the Fourth Circuit, does not agree with the suggestion that attorney-client privilege is waived by conference. And so, take a look at this particular case. This is a U.S. District Court case. This is the Callahan versus Toys R Us case. Okay. Again, this is a case that I keep in my notebook whenever I'm conferring with my client, and the attorney wants to ask about what did I confer with my client during the break. So again, the Fourth Circuit specifically does not agree with the suggestion that the attorney-client privilege is waived by such a conference. Okay. However, there are ways around it and ways to get at what happened during this communication, whether or not it affected the type of testimony that happened. So here's a way that I kind of combat that whenever I have a witness that has conferred with their attorney during the break. So when they come back in after the break, one of the questions I ask is, Mr. and Mrs. Jones, we've just taken a break during the deposition. Did you have the opportunity to talk with your lawyer during the break? Which is a fair question. The witness is going to say yes or no, they did. And specifically, I go back, and this is the question that I ask. Is there any testimony that you feel you need to clarify or correct since you've had the opportunity to talk with your lawyer? At the end of the day, you don't really care what the answer is. You're okay with whatever the answer is, because what you've just done is created a record. You've created a record that there was a conference with the attorney and with that particular witness over the break. And even better, if they come back and they say, well, I think I do need to change my answer, then an absolutely perfect question. How do you need to change your answer? And now you've got the record created that they had a conference with their attorney, and now they've come back in and they need to change an answer to a question. Sure.
In a depo, and you ask an important question of the deponent, and they get the whisper in the ear from their lawyer and they want to take a break before they answer the question. Do you push for an answer before they go out and confer with a lawyer?
Absolutely. Absolutely. And that's a very good question, because essentially, and I'm going to show you my rules and some of the rules that I give before we start the deposition so that everybody understands what we are doing during the deposition. That means the witness as well as the opposing counsel in the case. And one of the things that I tell them is that before we take a break, I have an absolute right to have an answer on the record before we take any break to any question that is pending. Okay? And I make that clear
expectation up front.
I'm sorry, go ahead, Ken.
You set that expectation up front.
Absolutely. Absolutely. And I know that North Carolina rules allow that there be an answer on the record before taking a break and going out and having such a conference. And the reason you want an answer is for what I just, for the reason I just said. You want to make sure that you have an answer so that they go out and then confer with their attorney and they come back in and change that answer. You've created a record. And again, this is one of the reasons that you want to make sure that you video record all of your depositions. You want to get that whisper. You want to get that tap on the shoulder and the lean over to speak with the witness and then say on the record, hey, I need the opportunity to confer with the witness. So you want to make sure that you create that record and have that on the record for if you need to do a motion to compel or if you need to reopen the deposition later.
That's what I wanted to hear, because I've been in some depots where there's been a bit of a struggle when that happens. I've got a few questions logged, and you can tell me whether this is a timely time to respond to these or if this is something you're going to be dealing with later. An anonymous attendee has said, can you tell me how to deal at depot and cross-exam when an adverse witness answers, well, if you say so?
Okay. And we can talk about, I'm going to talk about that and pretty much dealing with the witness and the witness questions. I'm sorry, the witness responses a little bit later, but
and we'll hold on to that one and let you keep going because you're on a roll.
Okay. Okay. All right. So we're talking about this whole aspect of what to do when there's been this question asked about opposing counsel about having the opportunity to confer with the witness, or if the witness asked to go on break and you believe that there's been a conference with the attorney. Okay, so this is important, and I did the CLE a few months back, and this was something that some of the attendees just did not know. The Fourth Circuit looks at this attorney-client privilege as just that, the privilege between the attorney and the client. If you have your own expert who is being deposed and you need a moment to speak with your expert, just know that as far as the Fourth Circuit, that is not something that is covered by attorney-client privilege. And that expert witness is not someone who you represent. There's no lawyer-client relationship with them. And so therefore, there is no right to any assistance of counsel during that particular conference that you've asked for. And so just know that. And again, that's that Callahan case. Again, I do a lot of cases in federal court, but I also do quite a bit in state court. And this is something that comes up, especially when the opposing party, I'm deposing the opposing party's expert and they want to have a conversation with their expert. There is no attorney-client privilege between that expert and that lawyer. And that's something good to know if they want a conference. Okay. Also, you want to take a look because that particular case talks about that one of the reasons that there's no right to that is that you don't want the other side impeding your ability to ask questions of that particular witness. And that particular court looked at such actions by opposing counsel in that case as being sanctionable. And we're going to talk about, the request for sanctions a little later for things that take place during the deposition. But that is always something to have in your back pocket and talk about the fact that there is no right and such requests have been deemed to be sanctionable and provide them the authority that you have. Another good reason to have your notebook and have your materials in it and know your materials. Another big thing, for those of you who practice in state court or even in federal court in different districts, know what your local rules are. know what your local rules are and what they allow you to do during the course of a deposition. And I'm going to talk about some things that North Carolina rules allow for us and your particular jurisdiction may allow also. This is from a North Carolina court, North Carolina Business Court. This is a rule from the North Carolina Business Court rules that are absolutely fantastic. And I use them in every one of my cases that I'm doing in state court because they apply to regular state courts also. And what it says is that counsel and any witness may not engage in private off-the-record conferences while a question is pending. So Kim, I knew I had that in there. I wanted to come back to your question because this is something that I use during the course of a deposition when they want to talk off the record after I've asked a question. So I have the authority in my notebook where I can go back to that says you don't have a right to that until you've answered that. Okay. Speaking objections, that's another big one. And that is one of my pet peeves during depositions, attorneys who want to do speaking objections. And there's different ways to handle the speaking objections. And I will be the first one to say that not all times do I handle it the appropriate way. So I'm going to tell you, do as I say, not as I do. And hopefully this helps you get through with some of those speaking objections. And so when we're talking about that, those speaking objections, so the federal rules talk about requires objections to be stated concisely on the record. However, North Carolina rule does not contain any similar provision. However, when we're looking at that, again, this is another business court rule. It talks about the objection should be succinct and state only the basis of the objection, which goes hand in hand with what the federal rule says. And again, I keep these business court rules in my notebook because they apply in regular cases in state court also. Here's another great case that you need to make sure that you keep handy. This particular case sounds like counsel in a lot of my cases. They made over 100 improper leading and speaking objections during the course of a deposition. Not only did the court grant the motion to compel, but they also awarded sanctions in the case, which were also, in that particular case, if you look at it, the sanctions were attorney's fees as well as the reopening of the deposition for counsel to go back and redo that deposition. Instructions not to answer. Well, this is a very important aspect of a deposition because there's only certain times where this applies. And attorneys really misuse this quite a bit during the deposition. So when we're talking about the federal rule and what the federal rules talk about, again, this is in Rule 30. There's only 3 situations during the course of a deposition that this type of instruction is allowed to reserve or preserve a privilege in a case, to enforce a limitation that's been set by the court through some type of protective order, and the opportunity to present a motion to terminate or limit the deposition under Rule 30, which I have used in a case before. So those are the only 3 times that you can instruct a witness not to answer the question. Just keep in mind that third option there, if you choose to do that option, the court has the opportunity to reopen the deposition and allow it to continue forward at the point where you stop. Okay. North Carolina Rules of Civil Procedure doesn't have any type provision in it. However, it does require the same limitations or instructions not to answer as the North Carolina trial courts have pretty much set in place, which pretty much follow the federal rules. One of my other pet peeves, when you ask a question of the witness and the attorney objects, and in that same breath states, you may answer if you know. That is an improper objection. I've heard both plaintiffs as well as defense attorneys actually use those types of objections during the course of a deposition, and they are improper. And the court, in this particular case, this is Cincinnati Insurance versus the Serrano case. And the court in that particular case said that it was at its finest point, raw, unmitigated coaching, which was never appropriate. The Fourth Circuit said that if the whole idea of saying, if you know objections, invited a witness to answer, I don't know. And this is extremely important if you practice in the Fourth Circuit, because there's case law on it. It is sanctionable conduct. In this particular case, the Mills v. GM case, the court not only ordered attorney's fees to be paid, but it ordered that the cost of the deposition be paid for by the counsel who made such objection and made such statements during the course of the deposition, and also reopened the deposition. Okay, so keep that in mind, that sanctions are appropriate if you make those types of statements during the course of a deposition. Okay, tactical interruptions during the depositions are prohibited, and I talked about this just a few moments ago. If objections during depositions are being made just to break up questions in depositions, they are never proper, and such actions can, again, if a clear record is made, are sanctionable by the court. Okay, the lawyer is not an intermediary, and I love this, because sometimes you get during the course and scope of a deposition that a lawyer hears you ask a question and then tries to interpret what you are asking in that question to the witness who is being questioned. That is never proper. That is never proper. And that witness has the duty to ask whether or not they need the question repeated or rephrased. That is not something that an attorney can do. However, a proper objection in that particular question, in that particular situation, if the attorney does not believe that the question is a proper question or that the witness may not understand it, is objection to the form of the question, not restating the question for the witness.
Can we pause for a second and
Absolutely.
talk about how many times this happens?
All the time. Yes.
Yeah. And I don't know if it's because lawyers think the other lawyer doesn't know any better and they can get away with it. Or, you know, do they really not know, or they're just trying to pull one over on you because they think you don't know? But that, I have seen this way too much. How about you?
I see this quite a few times during depositions. And the thing is, I know the difference in what can be done in depositions. And so I know that I have the right to object. I have the right to, you know, do certain things, such as ask that the deposition be paused till we get a judge on the line to actually state whether or not it's proper for the deposition to go forward. But a lot of attorneys just don't know the rules, and so they allow it to happen. And I think it goes both ways. Number one, the person who's defending the deposition simply doesn't know that they have a right to, they don't have a right to ask those types of questions. And then the person who's asking the question doesn't know that they don't have a right to tell the opposing attorney, you can't ask that type of question. That's why it's very imperative that we know the rules. And like I said, it's really amazing, you know, at the number of attorneys who don't know the difference in what can be done in the deposition and what they can do properly and what they can't do properly.
This is something where I feel like people need to keep a recording of what you've just explained. Use this in-house for your in-house CLEs. I've seen in my experience that a lot of people need a primer on this. We'll give them the benefit of the doubt for just not knowing.
Yeah.
For those who don't know, it's time for some re-education. So thank you for covering that.
Yeah, that's no problem. And like I said, my goal in this particular presentation is kind of cover a lot of the hot topics that we see happening during these depositions. Let's see. Again, this kind of clarifies it a little bit better. You know, counsel are not permitted to state on the record their interpretations of questions. And this, you know, lays it out very plainly. Again, this is another case I keep in my notebook. If you want to jot the case down, you know, it's very important that we make sure that type of thing does not happen, because the way they're interpreting to the particular witness may not be the way that you intended the question to be. So it's your job to ask the questions during the depositions, the witness's job to answer, the attorney's job to object if there's an issue with form. Preemptive objections at the beginning of the deposition, and this is what we started talking about a little earlier. These are the rules that I give during the beginning of the deposition. Will you tell me if you don't understand any of my questions? Will you let me know if any of my questions are confusing? Will you tell me if I assumed a fact incorrectly? Will you tell me if you don't know the answer to a question? And can you remember these rules throughout the course of this deposition? You know, and for different situations, I may add a few different ones into those particular rules, but I like to give those rules at the beginning of my deposition. And one of the things that I do, if I have an attorney who objects during the deposition, and they object because they say that the witness doesn't understand the question, or there's a issue with how the question has been asked. One of the ways that I like to kind of slap a opponent down, nicely, by the way, is that I will go back and I will ask the witness, Mr. and Mrs. Witness, I ask you the following question, and I'll repeat my question. And I'll say, Mr. and Mrs. Witness, did you understand the question that I just asked you? And they'll answer yes or no. And most of the time is yes, I understood the question. And I'll say, you know, your attorney just objects, stating that you may not have understood the question, you know, but you do in fact understand the question. Yes, and I continue on. Kim, I see you popped up. I'm running short on my time.
Well, we're at the 45-minute mark, and I don't want you to miss any good closing portions of your presentation. I would think we need to wrap up in the next 5 minutes so we can allow time for some questions, but please finish your important thoughts.
Absolutely. So let me kind of go forward from this particular slide. I got a couple other things. Let's see how to deal with unacceptable objections. So you don't want to get caught up in a match where you're bickering back and forth on the record. And so that's extremely important, because and a lot of times you've got a client who is there with you, and you want to make sure that you're showing them appropriate behavior and how they need to behave. Okay. And so to this end, don't do this. You know, I say that, you know, from time to time, I don't handle it the way that I should handle it. And, you know, sometimes, you know, I feel like doing it. I've never done that. I don't know what would happen if I did that, but, you know, I haven't done that, but I felt like doing that before. But what I would tell you is, you know, find your inner zen. Find your inner zen and know what your local rules say about how to handle these particular situations. And this is the importance of knowing your local rules. One of the things that I have the advantage of here in North Carolina is that my local rules tell me who the chief resident superior court judge and state court is for every county that I practice in. And so when I have this particular issue come up, you know, I may say something to the effect of, please don't make those kind of comments in front of the witness. I may tell them, you know, I may point out that there's case law or the rules don't allow that particular type of objection or those statements on the record. But if it continues, what I try to do is ignore those objections, continue on like those objections. I don't even hear them during the course and scope of the deposition, or I actually address those objections in a polite way, or I call back the question about the basis of the objection. So I make sure I make a clear record, because it's very important to make sure you make a clear record. I also like to meet and confer about those objections. And if there's an issue on the record that we can't get handled during the deposition, I'm going to immediately send an email following deposition. I'm going to tell them about what my concerns are. I'm going to advise the lawyer, you know, not aware, you know, that he may not be aware of the law and what the law says, but I'm going to give them the law on it. I'm going to educate them on it. And I'm going to work going forward on getting stipulations about the deposition, which can be handled by doing, you know, building my record, make it, because the court wants to see that we're trying to resolve these things and not bringing, you know, as my kids do all the time, nitpicky stuff to me for me to resolve. They want to see that we can act like adults and get these things resolved. However, if I can't handle those behaviors, then you best believe I'm going to go tell it. And when I go and tell it, I'm going to bring to the court's attention through a protective order or through some type of motion where I make the court have an understanding of what's been taking place during the deposition, which is allowed by me making some type of protective order motion. I'm going to move for sanctions and ask that the deposition be reopened, because the law allows that. And you can best believe that after I get the sanctions in the case, I'm going to let them know who won. And this is what I'm going to feel like the next time I see them at the deposition. Ladies and gentlemen, that's going to be it for my presentation. You know, just remember that what we do with planning for these depositions and how we handle the depositions, This is a chess match. This is not checkers. And so when we go into these things, we've got to have an understanding of how to best handle them. And your preparation should not be done at the deposition. It's got to be done before. So I appreciate your time today, and happy to answer any questions or anything that you have.
This is great stuff. This is very practical education and things that people can start employing right away. One of our anonymous attendees is asking, how do you deal when you catch an adverse witness clearly lying?
Well, of course, what you're going to want to do is you're going to want to jump all over it. And sometimes in your excitement, you lose the fact that the non-truth has just been stated. So I have a law partner, David Ventura, that's really taught me a lot over the years and how to handle these things in the deposition. And, quite frankly, we call each other Crockett and Tubbs, because I'm pretty much the and for those of you who don't know, that's a Miami Vice reference. That's an old show. I'm that old. And so, how to handle those types of things during depositions. And what I've learned from him is he is so calm and is so concise in how he goes back and handles those type of situations. And one of the things he does when he finds something that is untrue is that he gives the witness an opportunity to fix the untruth. When the witness does not fix the untruth, what we like to do is plan ahead, and we think about things that a witness may be untruthful about, and we have some type of documentation or some type of record that we can present to them to walk them through that untruth. And it may be something as a statement. I've got a case right now where I'm dealing with an OSHA report. And in the OSHA report, because it was a federal investigation, at the bottom of the report, it talks about how the statement is being made under the penalty of perjury, and how there can be a $10,000 fine if the person has perjured themselves. So I give them the opportunity to, talk about the untruth and give them a chance to fix it. And when I see that they're not fixing it, I will then show them their statement or whatever they've done before. And if it's a situation where I've got something great, like, under the penalty of perjury, I'll say, when you wrote this statement, did they explain to you that this was under the penalty of perjury? And that was essentially you taking an oath, just like you took an oath here today to tell the truth. And there was also the penalty that you could be fined up to $10,000 if you perjured yourself. Is that fair? So here's my question. You've told us something different here today. However, you wrote something different in your statement. And all I'm asking you for today is, which one's the truth? And I give them the opportunity to fix that at that point. I don't care what their answer is. I don't care what it is. And again, I video recorded the deposition. So guess what? I'm going to play that excerpt at trial.
There you go. My only question, piggybacking on this, is whether you save that for trial. If you just lay the foundation in the depo and then move in for the kill at trial, or if you deal with it. But it sounds like you're being super fair. And you've already established on the depo record that they've told two different stories. So your work was done.
Yeah, I think there's two trains of thought on that. And one says you wait to handle it at trial. The other one says, and this is the tack that I take. I've had the opportunity to learn from some really good attorneys over the years. And the aspect that I take whenever I take a deposition, which goes into my preparation beforehand, is I am taking that deposition as a for-trial deposition. So everything that I do in that deposition, I am gearing towards using that deposition at trial and not even placing that witness on the stand for that particular point. Yeah. So I want to get it out while I'm in the deposition, because if it's bad enough, they may be coached to say something different at trial. So just because I got it on the record during deposition doesn't mean I'm going to have that great testimony at trial. Right. So again, video record your depositions, because once you video recorded it, it's done.
Very good. There's another question. It says, how do I deal when they claim I forgot or I don't recall? And that keeps coming up over and over in a depo. I don't know. I don't recall.
Well, I've had clients that have done that before. And I'll tell you, it really puts you in a hot seat as an attorney, because some of the things they're being asked are things that you believe they actually should know, or, in some cases, the folks are nervous and that, they just don't know. You want to be very delicate on how you handle that. And again, I try to take the tact my partner takes. Don't always do it because sometimes I get, a little pissed in depositions that every answer is coming up, I don't know, or I don't remember. So the way that I like to handle it is this. I'll give you maybe 4 times to say that during the deposition. Before I'm going to come back and I'm going to slap you on the hand about it. And I'm going to go back, and this is what I'm going to ask the question. Mr. and Mrs. Witness, before we begin the deposition, I asked you whether or not you were taking any medications that would impair your ability to remember things in this deposition. Are you taking any medications that would impair your memory? No. Have you done anything that would cause you to have an impaired memory, such as have some type of head injury, anything of that nature? No. So let me ask you this. Is it just a situation where you just have a very bad memory? Again, I don't really care what the answers are, but I'm really putting this on the record so that the witness becomes ashamed and embarrassed based on telling me so many times, I don't know, or I don't remember. And then again, when I play it back for the jury sees that I've attempted to be fair by giving that witness the opportunity to tell me anything that may have impaired their memory.
Okay, I like that very much. There's a question here that says, can we have a link to Trial Lawyer Nation episode where you were featured? I'm aware of the series by Michael Cowan, but didn't catch yours. I have posted your email address in the chat. And so I would encourage that anonymous attendee to reach out to you to get that. So
absolutely, I'm happy to share that. Which, by the way, yeah, that is a very good podcast. Very good podcast.
Okay, and questions are coming in. If you are available to keep going, we will have another anonymous attendee that says, "Please put the case cite federal law in the Q&A. Could not copy it fast enough. Great webinar, especially idea of having only." Only have outlines, so better paying attention to answers, have to think further about the details in chapters. So that's good. I would, this same anonymous attendee, send that question to him, but with Karonnie's permission, we can share the slides and that's going to have all of those citations. Is that okay with you if we share that with people who reach out for it?
I think that's fine.
Okay, so I have logged my email and Michelle Connolly's email in the chat as well. So reach out to us for a list of things you want, and we can send you not only a recording of this entire thing, but we can send you the PowerPoint so you'll have all of those citations handy. How do you respond to an adverse witness that responds to a question, I don't want to answer that, or I don't have to answer that?
You tell them thank you for the biggest gift that they have ever given you. Because whenever I hear a response like that, again, your first good is y'all just going to dive in. But you need to take some time and think exactly how you want to respond to that. Again, and you're going to hear me repeat this like I am a broken record. Record your depositions because you cannot recreate that the way that it appears during the deposition. Because often when they say something to that effect, there's a facial feature that comes along with it. And so what I like to do is, again, I'm going to play the good guy that I am. And I'm going to ask them and say, Mr. Witness, I absolutely understand your concern with answering that question. However, I'm sure your attorney is going to tell you that today is my opportunity to ask you questions about things that are relative and that I need to know about this case. And your attorney is going to instruct you that in my questions today, your job is to answer the questions that I'm asking you and not obstruct my ability to gain information based on this deposition. Do you understand that, Mr. Witness? Now, I'm very considerate about your position. So I want to ask you, can you tell us why you don't want to answer that question? And I don't care what the answer is, because really at that point, I'm just prodding them at that point. Because, either they're going to tell me a very valid answer, which I'm not going to go into any detail about if it's something that really slaps me in the face.
Mhm.
But if it's not something that slaps me in the face, I'm going to continue asking questions about it, because now I've got that this witness does not want to answer that question. And it is a potential that I may have a hot button that leads to something else that may help my case.
There you go. Very good. And it's all being recorded. Someone's asking, how would you prepare for a pro se litigant deposing your client? Anything special you do for that?
Well, one of the things that I will tell you, I've never had that situation where there's a pro se litigant. But one of the things that I would do, because, I've seen what happens with pro se litigants. One of the things that I think you would best serve yourself is by, prior to the deposition, filing a motion for a protective order, getting it heard in front of a judge so that the judge may limit and restrict the questions that are going to be asked. I would also request in that motion for protective order that particular pro se litigant provide a set of topics that they intend to ask the witness about. I think that that's fair, and it will also allow the court to properly restrict questions that should not be asked.
Okay, very good. So you're hitting that proactively. Another person is saying, great webinar. Would ask him to please email, send participants case law. Everybody that wants a recording of this webinar, email me and we'll send them all out at the same time. It's kim.white@case-metrix.com. You'll also see that email address in the chat. Trey Mark, hello, Trey. He's saying, could you possibly post a list of cases you've mentioned? That's the same thing. We'll do that. Juanita Powell Williams is saying this presentation is invaluable. Thank you. We always like the nice comments that come through. Roxanne Connell is asking, are the slides available? Yes. How about if we ask Karonnie to share the slides and ask me for the recordings, and you'll have both those emails in the chat. So look at those now and take those down. Anonymous attendee, specifically, what does your partner say when untruthed? I'm reading that verbatim. Do you understand what that question is asking?
I don't know that I necessarily understand what that
We might ask that person to clarify that question for us, please.
Yeah, that would be great.
Yes, presentations will be available to attendees. Ask him for those. Here's another one. Have you ever actually done, or are you aware of any cases where actually perjury charges were brought in a civil trial? I have not, only if lied to a grand jury or FBI or criminal cases, but have you had this happen in a civil trial where there were actual perjury charges brought?
Interestingly enough, I've not. But a lot of those, again, I do quite a bit in federal court, and a lot of those different forms that were done by the, federal organization have that little clause at the bottom of the statements. And so I would challenge you, if you got any of those cases, to take a look at it, because I will tell you, the first time that you show that to a witness during the deposition, it freaks them out. Because a lot of times they don't understand what they've actually signed or the power of what they've actually signed. And I will tell you, there is nothing better than getting ready for a trial and knowing that you've got something like that in your back pocket. But to answer that question, no, I've never had where those types of charges have been brought.
Okay. I think your warnings are doing their job then. Philip Fabiano is asking, my response to I don't remember or I don't know is, when you say you don't know, are you leaving open the possibility that ... That's good.
Oh, that's great.
I like that too. Thank you, Philip, for sharing that with everybody. Stacy, yes, recording will be available. Email me if you want a copy of the recording. Lisa Metcalf is asking us, the webinar is approved for CLE credit for CLAs. We normally leave that to our webinar host, whether they want to apply for CLEs. So I would ask you to direct that question to Karonnie And Karonnie, let me know if you are seeking CLE credits for this particular event.
And Kim, I will tell you that it's been applied for. This is one that I did last summer that was approved for credit, and so I've applied based on that again. And so I absolutely believe it's going to be approved for credit, and I can get that information to whoever needs it.
Okay, and once you know one way or the other, let me know that. So if other people reach out to me afterwards. Incidentally, I know there are people sometimes that have to leave early, or they had intended to attend today and they weren't able to. Reach out to me if you want a recording. I'll be glad to send that to you. We will also post a recording of this on the Case Metrics YouTube page, which you'll find on our mailings. Any other questions that come up afterwards, you look in the chat so you have everybody's contact information from that. For those of you who are not already Case Metrics subscribers and are interested in looking at this, one of the benefits of attending today is you can look inside the live Case Metrics settlement and verdict database free of charge for 10 minutes. Just email Michelle or me and give us some available dates and times, and we'll be glad to set that up for you. During that time, you can tell us about one case you're evaluating now, and we can use that as part of the demo. And it's just a quick little Zoom call, and we'll pull up a list of recent settlements and cases and similar to one that you're evaluating now to let you look at the actual settlement and verdict data in the interest of making sure you're getting the best settlement possible for your client. It doesn't cost you anything, and you should take us up on it for sure. And that's what our lawyers do all the time. The data is updated every 15 minutes. It's there. It's a chance to look at it for free. So definitely reach out and we'll set that up for you. Let me just double check to see if we have any more questions, because we were on a roll there with questions. And
Kim, what I would say is to anyone who's not, who hasn't tried, Case Metrics before, we use that quite frequently, and in preparing. Again, I talked with you guys early on about preparing early about what we do on these cases. And I think that is a tool that is uniquely designed so that you can speak with your client and be able to prepare them about similar type cases and similar type liability issues. And it also gives you the opportunity to look at liability issues so that you can prepare for your deposition. So I would definitely tell you guys who have not had the opportunity to use that before, definitely take advantage of it and see how you can use it in your practice.
We definitely appreciate that coming from you. Thank you so much. Somebody else has chimed in. Regina Balzan has said, great presentation. Please have him do others. We would love to do that if you were willing to do so. This was great. I always love the webinars we do where lawyers who've been doing this for a while have either developed a niche in a particular type of practice, or they come to us with super practical advice of things that you can start using. Like in this one, you can start using this in your next depo. So this is hugely valuable. And I love the way you presented it. Thank you for making it interactive and addressing all the questions that came up today. I'm sure more questions are going to come your way afterwards. Again, guys, feel free to share the recordings with other people that you work with, spreading the word. And if you have any cases you want Karonnie to review for you, maybe you're not practicing in North Carolina, you've got a North Carolina case you want to send his way or confer with him on it, his contact information is in there. So feel free to reach out to him for those too. I don't think we have any other questions. Any other final comments from you, Karonnie, before we let you get back to work?
No, I think that, with regards to these depositions, I think it's very important how we take these. And if you take a look at your case from the beginning and use your depositions as something that you're preparing for trial, you're always going to do the preparation ahead of time and make these the best depositions possible so you get the information out that you need. And dealing with the obstructions are just one piece of that whole idea when you put those deposition outlines together.
I totally agree. The bosses that raised me in my paralegal days said every depo and every discovery response is your playbook for trial. Treat it as such. Treat every case as that it's going to be tried. And those things were front and center. And I knew them inside and out at every trial, which is why they took me with them, even as a paralegal, to know those things inside and out. So when somebody testifies to the contrary, you're ready to go. You've already laid that foundation. So we Thank you for impressing upon us the importance of laying that foundation and doing it in such a masterful way, and in such a kind and gentlemanly way. We always love talking to you. Thank you so very much for your time. Guys, if you need anything else, reach out to Karonnie at, looking for here, let's see if I still have this on here. Tell them your email address real quick again, Karonnie.
It's going to be K.R. Truzy, Truzy, at crlegalteam.com.
Okay. And I am at kim.white at case-metrics, metrix.com. Michelle Connolly, also in sales at Case Metrics, is at Michelle, Michelle.Connolly, Connolly, at case-metrics.com. And we will be glad to get you anything else you need or set up a demo with you if you guys want to do that. Thanks to everyone for attending, and look forward to our next webinar with Mike Haggard that you will be learning about very soon. That's happening in February. Thanks to everybody, especially our host, and have a great day. Bye-bye.
Thanks, everybody.